You all up in my titty.
Don't
You all
face.
get out. Turn your camera on.
Ma'am,
You all in my titty.
I need to.
You all in my titty. You're in my titty. You're in my titty. You're funny. You're in my titty.
On a public sidewalk late at night, police responded to a disturbance involving a 55-year-old woman. What started as a verbal confrontation escalated within minutes, ending with her detained, identified, and arrested on a misdemeanor charge.
What's the issue?
So you don't have no members left? What's going on?
About some racist.
Racist? I'm talking to you about your family member. Oh, they're racist.
What's she saying?
No.
I have a bunch of check, but somewhere along the line, did you see how this country's going?
Yeah. Did you not see how racist was when they
I'll
voted?
over here. You had idea.
This is my car.
Is that a restaurant?
What's going on?
Why
are we getting calls about you?
Because he got hurt feelings.
About
I don't know. Ask him. No, through. Hold on. I called the cops and said, okay. Because I told him it don't matter who's president. The president's going to put your country. Oh, you're crazy. No, I'm not. And it went on.
Do you have idea?
I want to talk to the attorney.
Okay.
I want to talk to a lawyer right now at this moment.
Do you have a lawyer?
I'll get one. Or book me in and I'll find one.
What?
Book me in and I'll find one.
Okay. What's your plan for the rest of the night?
That's where I'm going. You want to hang out here to talk to you. Why? I don't know. You said hang out here. Okay. Why you want me to talk to you? I don't know. No, rest me. I'll go. No problem.
Why do you want to go to jail? Did you do anything?
I don't want to go to jail. He wants me to go to jail.
What happened?
So I come out. I'm going to get groceries. She came up and she's like asking something. She's like, girls, I was talking to her. You ran inside. I was gonna. So I walk in, starts to talk about how red it is, how I'm
Weirdo. You a weirdo. You act stupid. Ask me a real question. Ignorant fool.
Yeah, you've had quite a bit of drink.
No, I haven't.
No,
I haven't tried to drink. What I'm saying is you ask stupid. Like Trump said, you a Democrat. You act stupid. Ask stupid questions.
I don't think.
He asked me over here to talk to you. I come over here to talk to him. She's trying to figure out, bro.
Is anything happened between you guys?
No, I don't like him. He's not 6. I'm not attracted.
Did you punch him? Yeah.
Did he punch me?
So I'm trying to
Why don't
figure
you
out.
go ask him?
I'm asking
I'd
you.
start taking videos. I didn't say that. Yell, talking. She's like, you have your country. It's like just absolutely not. Then I got to punch her. I'm trying to leave. She's like, in the car. It's real thing. I was like, I don't want to touch the car.
You want to pursue charges?
No. I mean, what is Crosse?
It'll be a ticket.
Okay. Yeah.
That's
good.
He did. He touched me. He pushed me like this.
Pushed you?
Yeah.
Did you push him?
You know better. No, I didn't touch each other. Why you acting stupid and asking stupid questions?
Ma'am.
Ignorant. No, he's asking stupid. No, I'm not giving you an ID.
So here's the thing.
Then take me to jail. I'm not giving you an ID.
Here, let me talk.
I'm not giving you an ID. He asked me over. He talking stupid. Call me a white crank. What's a crank? What the is a crank? Ask him.
So
No, you coming over here. Threat is what you're doing. Once you bring them shoulders back and quit acting like I'm a criminal. How about that?
are you done talking?
How about you be done talking?
Well, you haven't.
Well, no, because you already took his side. So bring your shoulders down because they don't scare me. Those in I know.
I'm just trying to talk. I'm not trying to.
Well, then talk. Quit like that at me. Because it don't work. Makes me more angry. When a man acts like they can dominate a woman, it's stupid.
We're just out here with you.
No, was standing here and he came to me. No, I didn't. That's what he said. I could tell you what he said. Would you believe me? You say it sounds like you said this. Boss. No, it don't matter. In court of law, he said boss. So don't bring that to me.
Well, I'm just trying to.
No.
Are you gonna? Do you have idea?
No, I'm not giving you any ID me.
What's your name?
It don't matter. Ask him. He's the one that called you. You gonna put on gloves? I was like, I'm gonna race. I gotta put on gloves.
Why?
Is that it? What you doing?
I just like to
Let's go. He wants to race me.
What's your name?
He wants to race me. Go ahead.
What's your
I
name?
ain't giving you that.
If you don't give me your name, you're
All right, let's go.
This is where the legal boundary tightens. Continued resistance to positioning and instructions allows officers to shift from a consensual encounter into investigative detention.
If you're on probation.
All right, because I want to give you my name.
I tried to give you plenty to talk to me.
Yeah, he's the one that said it.
I know. I'm not going to play these games.
I didn't say that.
Okay, so you are going to jail. There's nothing in my mind about that.
Say that. Cigarette. That's all right.
You're also going to have no contact.
Who? Where is it? What is
Do you have a shirt under this?
Yeah. What is this place? I'm asking. You ain't gonna tell me?
I don't know. You tell me.
I don't know. I think about it.
You are correct.
Quit. I'm done. What are you looking for?
We have to empty all your pockets.
What?
We have to empty all your pockets.
I ain't got what are you trying to get my money?
I have.
What do you want? I ain't got news. Think I'm a terrorist? Weirdo. You all up in my teeth. You all up in my teeth. You all. Get out. Turn your camera on. You all in my teeth. You all in my teeth. You're in my teeth. You're in my teeth. Oh well. That. I forgot about that. You so naughty.
You provide a sample to see how much you've been drinking?
Nope. You gotta get my lawyer.
Who's your lawyer? I'll call him.
After being placed inside the squad car, she began aggressively barking at Canine Rock.
Lawyer.
I was effective.
Did they say any odds? I did. He said he had some videos to grab. Hey, Mike, real quick. I think the crime read it. Let me know.
Picture yourself walking through a familiar public space at the end of an ordinary day. A sidewalk, a storefront, people passing by without concern. Nothing about this moment feels dangerous. Nothing suggests custody. Nothing hints at handcuffs or jail. This is the kind of place where people believe words are harmless, where speaking loudly feels protected, where refusing to engage feels safe. In everyday life, these assumptions usually hold. You say what you want, you walk away, and the moment dissolves. But here, it doesn't. A casual interaction hardens into a confrontation, not because of violence, not because of threats, simply because someone believes that as long as the dispute stays verbal, the law stays distant. That belief is powerful and deeply misleading. Within minutes, the atmosphere shifts, movement slows, voices stop mattering. What felt like a debate becomes a process. What felt like personal control quietly disappears. The outcome is no longer emotional. It's procedural. Handcuffs are applied. Custody follows. Charges are filed. Jail exposure becomes real. This is the cognitive shock. The setting never changed. The danger never escalated. Only one assumption failed: the idea that refusing to comply in a public confrontation carries no consequences. Stay with this moment. The logic that turns a sidewalk argument into an arrest isn't obvious yet, but once it's revealed, the ending becomes impossible to avoid. The central question here is not about opinions, tone, or even offensive language. It is far more specific and far more misunderstood. At what point does a public argument stop being protected speech and become a lawful basis for arrest? Many people believe there is a clear shield. If no one is struck, no property is damaged, and no threats are made, police authority remains limited. That belief is the legal myth driving this encounter. It sounds reasonable, it feels intuitive, and it is wrong. By the end of this video, you will understand why the things she believed would protect her is exactly what made arrest inevitable. The law does not turn on feelings or intent, it turns on thresholds. Once those thresholds are crossed, discretion narrows and outcomes harden. The rest of this case flows from that single misunderstanding. The encounter begins with a call reporting a disturbance in a public area outside a commercial location. No allegation of a serious crime, no weapons reported, just a verbal confrontation that escalated enough for someone to request intervention. When authority arrives, the scene is already fractured. One party reports feeling harassed and intimidated. The other insists nothing unlawful occurred and attempts to disengage. At this stage, the interaction remains investigatory. No one is detained. No one is under arrest. The legal posture is still fluid. But several details matter. The confrontation is ongoing. Voices are raised. The setting is public. And officers are now tasked with determining whether the behavior meets the threshold for a minor public order offense. That requires identification, not to punish speech, but to document and resolve the call. This is where the timeline compresses. Instead of de-escalation, the exchange loops. Questions are met with refusal. Instructions are challenged. The focus shifts away from the original dispute and toward compliance itself. Each response narrows the available options. Each minute removes flexibility. Nothing dramatic has happened yet. But the path forward is already being shaped, quietly, procedurally, and almost invisibly. Everything changes here. Up to this point, the encounter exists in a gray zone, an investigation without detention, a conversation without custody. The legal balance is still adjustable. Officers can disengage, the parties can separate, the situation can dissolve. Then, a single decision collapses that flexibility. When lawful identification is requested to resolve an active public disturbance, refusal is no longer neutral. It is no longer passive. The moment compliance is explicitly declined, the legal dynamic shifts from dialogue to enforcement. The moment refusal becomes persistent, the focus is no longer the original dispute. It is obstruction of a lawful investigation. At that point, intent stops mattering. Tone stops mattering. Even the underlying argument stops mattering. The moment that refusal hardens, the threshold is crossed. This is not punishment for speech. This is not retaliation for attitude. This is the point where conduct interferes with process. Once that happens, discretion narrows rapidly. Options disappear. The outcome begins to lock. The arrest does not happen because the situation escalated emotionally. It happens because it escalated legally. From this moment forward, the result is no longer negotiable. The state change is complete. The legal axis here turns on a single misconception. Myth. If no one is touched, threatened, or injured, arrest is off the table. That belief collapses under public order statutes designed to preserve basic civic function. Most jurisdictions criminalize disorderly conduct or obstruction not to police opinions, but to prevent interference with lawful duties. The statute is narrow, but the threshold is clear. When conduct materially impedes an officer's ability to resolve an active disturbance, enforcement becomes objectively reasonable. Here is the distinction that matters: speech versus conduct. Speech includes opinions, insults, and even offensive language. Those alone do not create probable cause. Conduct, however, includes refusal to comply with lawful commands that are necessary to complete an investigation. Once identification is reasonably required to document, warn, or separate parties, persistent refusal stops being expressive. It becomes obstructive. This is where annoyance becomes interference. Officers do not need certainty of guilt to proceed. They need probable cause, a reasonable belief based on observable behavior that a statute is being violated. In a public disturbance call, that belief forms when the scene cannot be resolved without identification and the subject knowingly blocks that process. This is where explanation becomes justification. Claims of innocence do not negate the threshold. Disagreement does not erase authority, and asserting rights does not suspend procedure. The law evaluates what an objectively reasonable officer would conclude in that moment, not how the subject frames their intent. This is where refusal becomes resistance. Once the threshold is crossed, the statute authorizes custody to restore order and complete the investigation. The charge does not elevate because of attitude. It elevates because the legal options to resolve the encounter without enforcement have been exhausted. This is not discretionary punishment. It is statutory sequence. From that point forward, the arrest is not a choice. It is the next lawful step. The myth fails because it misunderstands what the law actually protects and what it requires when public order breaks down. Two counter-narratives surface immediately in cases like this. Both feel compelling. Neither alters the legal outcome. The first is free speech. Offensive language, political opinions, and verbal hostility are protected. But protection ends where speech becomes conduct. The legal test is not whether words were allowed. It is whether behavior obstructed a lawful process. Once identification is reasonably required to resolve an active disturbance, refusal is no longer expressive. It is operational interference. The second is police overreach. Viewers often assume escalation reflects personal frustration or authority abuse. The objective standard rejects that framing. The question is not how the encounter felt. It is whether a reasonable officer, faced with repeated noncompliance during an ongoing call, had lawful grounds to proceed. If the threshold is met, motive becomes irrelevant. This is where narrative collapses into procedure. The law does not weigh tone, politics, or perceived fairness. It applies tests. When those tests are satisfied, enforcement follows, not as punishment, but as resolution. What unfolds next reflects a recognizable behavioral pattern, not a psychological condition. This is not about diagnosis. It is about social response to authority. The pattern centers on entitlement and authority confusion, the belief that personal conviction can override procedural obligation. Each refusal is framed as self-defense. Each escalation is justified as provocation. Responsibility is displaced outward, while control is assumed to remain internal. This is where status insulation appears, the assumption that confidence, volume, or moral certainty creates a buffer against consequence. When that buffer fails, the response often flips into DARVO, deny, attack, and reverse victim and offender, casting enforcement itself as the wrongdoing. This is not a mental health diagnosis. This is a behavioral pattern. When unchecked, it reliably produces the same outcome: rapid loss of agency once formal authority engages. The encounter ends without ambiguity. A misdemeanor disorderly conduct charge is formally entered. Custody is completed. The subject is transported, searched, booked, and processed according to standard procedure. What began as a public argument now carries a criminal record, court dates, financial exposure, and temporary loss of freedom. The penalties are not dramatic, but they are real. Fines, mandatory appearances, conditions of release, restrictions on return to the location. Each consequence flows directly from the statutory threshold crossed earlier in the encounter. This outcome is often misunderstood. Some expect harsher punishment. Others expect none at all. The law delivers neither. It delivers proportion. Order is restored not through force, but through procedure. The disturbance ends. The public space resets. The system closes the loop it was designed to close. This is the final reversal. The law does not escalate to dominate. It escalates to conclude. Freedom in public spaces is not unlimited. It is conditional on compliance with minimal civic rules that allow others to exist without interference. When those limits are rejected, enforcement becomes necessary, not to suppress speech, but to preserve order. The result is not personal. It is structural. The law applies to everyone. Order is not oppression, and freedom without limits collapses into chaos.